Dr. Chang, thank you very much. Dean Liu, your university, Chang Tang, has a very good reputation also in Germany, so thank you very much. It's an honor to speak. We are talking about Germany now, and I remember Eric's presentation showing the dollar notes on the first page, and I do not know whether it is paradise or hell to see so much money in the US. Then I saw Ayumu's presentation, and you may remember the statistics with the damage claims. Germany was the very last country with almost zero damage claims. So thank you very much for this start from me. I will try to show you that Germany is somewhere in the middle between hell and paradise, and that damage claims are more than shown in the statistics. Before we go to the presentation, I would like to give some words about the legal system in Germany, because it may be interesting to understand the situation. We have 12 patent courts in Germany. There is forum shopping within Germany, and there is also some competition between the courts in Germany. So the three most important courts are the Düsseldorf, the Mannheim, and the Munich courts. They have most of the patent litigation, and my speech today will cover these three courts. We have no late juries. Thank you. We have no discovery. This is bad because attorneys cannot earn as much money as in the US. But it also shows a little bit about the court system. There are some differences, and you will see that Japan and Germany, I think, has more in common about procedural law, and probably also to Taiwan, than we have with the US. If you talk about technical issues, I think we are on the same level in all countries. So you see, I want to give you some idea about the German court system. It takes about 1 year until we have a decision of first instance, and there is one hearing which may last only 1 or 2 hours, and most of the work is done in writing, probably very similar to what you have here in Taiwan. Now, we talk about costs all the time, and I would like to show you one problem with costs. German judges who do patent litigation are good judges. Only the best jurists become judges, and usually patent judges are very clever people. However, the salary of a patent judge is not very high. So if you want to convince a patent judge to grant damages of several million, this is not his world. I mean, this is serious. It's not maybe not very reasonable, but we have to keep it in mind. Another thing about damages and the amount of damages. When you are the plaintiff and you go to court, you have to indicate a value of matter. This value of matter is important for several things. First, it defines the court fees, and the plaintiff has to pay the court fees in advance. Second, the losing party has to pay not only the court fees, but also attorney fees of the winning party. Third, if a non-European company files a suit in Germany, they may have to place a bond, a security. In other words, when you are a plaintiff in Germany, you have to indicate the value of matter for patent litigation. An average value of matter is something like 500,000 euro, €1 million. This defines the amount of court fees, the amount you may have to pay if you lose the case. There is always a risk, at least before German courts, not to win the case. And it also defines the amount of the possible deposit which you have to make. So now many clients, also Taiwanese clients, want to spend not too much money. They indicate a value of matter which is not very high, let's say $1 million. So now we win the case, and now we want to convince the court to pay 100 million damages. What will the judge say? Hey, you started with 1 million because you wanted to save court fees, and now you want 100 million. This is not reasonable. So you see, there is some contradiction which is a very practical thing. It is not a legal issue, but it's an issue which can be very important if you litigate in Germany as a non-European company. You think of these figures, you start with a comparably low value of matter, and then in the end, if you want a lot of money for damages, you have a problem because you contradict yourself in some way. So this shows why we do not have damage awards which are as high as in paradise. So this was, as a starter, some background also to show the economic and financial situation. Let's get back to law. We are in a university. So, Section 139 of the German Patent Act says, any person who performs the act intentionally or negligently shall be obliged to compensate the aggrieved party for the damage caused. This is German law. If you have a European patent, the European patent may be validated in Germany, so it has effect in Germany. And the European Patent Convention says something very similar. A European patent shall confer to its proprietor the same rights as would be conferred by a national patent granted in that state. In other words, if you start to litigate your European patent in Germany, and when we talk about damages, then we talk about national German damage law. There are three options to calculate the damage, and we already know it. It's own loss profit, infringer's profit, license analogy. Nothing new. Let's get back to the own loss profit. It is not used in Germany. Again, same as probably in Japan. The reason is simple. A German company who does not make profit on its product does not want to disclose it. If they make a lot of profit and they disclose it, any customer would immediately complain about the price and would try to decrease the profit. In other words, this exists in theory. I'm only do patent litigation for more than 20 years. We never had a case of own loss profit. Infringer's profit, we will come to it, and license analogy, yes, long discussion, we will come to it. These three methods are defined in the Patent Act. In addition, we have unjust enrichment claims. I learned from my Taiwanese partners just before that this is very common in Taiwan. In Germany, this is not very common. We usually trust in our patent law and the legal claim based in the patent law. So unjust enrichment is a part of the German civil code. It's something different to patent law, and that's one of the reasons why most of the very specialized patent litigators do not want to use it. We use it in one particular scenario, namely in case a statute of limitation is relevant. You have a patent infringement, you will get damages for the past 3 years. If the patent is old, there may be much more years than the past 3 years. How can we get back to the past? Then we go to unjust enrichment claims, because here the statute of limitation is 10 years. So you may have a chance to get more money for the past. It's not used very often, but it's an important factor when we calculate the damages. So my idea when preparing this presentation was, let's have a case. Let's give you a timeline and let's give you the options so that you see how all this develops. And now here we have a European patent. It is validated in Germany. It has been filed in 2008. It was published in 2008, and there was a grant in 2011. And let's assume it's for a mobile phone, and this is claim 1, comprising a configuration of a lot of features, and its display having an arrangement of OLEDs characterized in a certain technical way. By the way, this case here is a mix of two real cases, and we just tried to make it nice for everyone to understand the system. So in 2009, the patentee at the fair CeBIT, which is one of the famous fairs in Germany. Oh, by the way, Germany is good in litigation, and it is famous for preliminary injunctions. And you may hear horror stories from Taiwanese companies who go to a fair in Germany and suddenly someone comes from court, takes away all products from the fair. This is what German attorneys like. And this is also very dangerous. But this has nothing to do with damages. If a preliminary injunction is granted, it can stop any offering or sales. It will give a legal basis to take away infringing goods. But it has nothing to do with damages. So whatever you hear about preliminary injunctions in Germany can be very relevant, but it has nothing to do with damages. Even if you have a successful preliminary injunction, you have to start further proceedings to get damages. And the thing about preliminary injunctions in Germany is you can get them without a hearing, ex parte. They come immediately out of heaven, very dangerous. Okay, so at this fair CeBIT, we see that the patentee finds a product from copyprod, it's the production in Asia, and later on he tries to buy it because he has to collect evidence. Burden of evidence is with the plaintiff. This is a very important principle of German civil procedure. We do not have discovery, therefore burden of evidence is a very essential feature and a big step to take by the plaintiff. So he buys the product, he examines it for patent infringement. What we do next is we send a warning letter. We set a term of 2 weeks. The distributor does not act. So what will we do? Will we file the suit against copyprod, the production company? No, because it's in Asia. We take the easy way. We start with the litigation against the German distributor. So we file the suit against the German distributor. We do it in 2012. German procedural law does not allow discovery. The patentee needs information as to the extent of the infringement and the profits made. In other words, how should we know which damage we get unless we know how many pieces have been sold? What is the profit? So, German law provides the legal basis to get this information, and then based on this information, the concrete amount of damages can be calculated. In other words, we have a solution by stages. We have 2 steps. The first step means define infringement, get this information, and then only in the next step we calculate and we fight for the real payment of the damages. Which means if we go to court and we are here in this stage 1, we of course have the first motion to get a cease and desist declaration, to get an injunction. Then we have another motion which claims that the defendant is obliged to render information. To render information in detail about extent of infringement, prices, sales, profits, suppliers, customers, listed for the relevant year. This is a lot of information which has to be given by the infringer, and German law provides the basis to get this. Forcing the infringer to disclose this information is an important side effect of damage compensation. Most of the damage cases in Germany are settled out of court. Why? You get an injunction and the infringer is obliged to give information. The infringer hates to give this information because, well, what will I do as next step when I get the information? I will send the next warning letter to the customer because I earn money when sending the warning letter and because I may get damages from the customer. The customer will then go to the first infringer and will complain about him. And then the business of the infringer may have a damage which goes beyond this concrete product. And the infringer wants to avoid this. he is rather willing to pay a little bit more just to get rid of these obligation. So this is the reason why we have so little publication about damage cases in Germany. I forgot to say in the beginning something also particular about German cases. They are not published. Of course, you have a public hearing, but the hearing lasts only 1 hour. There is no public database about court hearings. So if you ask how many patent cases deciding an infringement exist in Germany, the judges will not know it. It's a decision between parties. It is not published. Sometimes the parties publish. If it's an important decision, the judges may publish, but the judges do not publish and are not allowed to publish the identity of the parties. The publication will only say patent owner and plaintiff and defendant. No identification of the parties. Therefore, it's so difficult to gain information about damage payments in Germany. And this is also the reason why in your statistics it showed almost zero. Clear, there is no publication. So there is damage compensation, it just is not shown. So this is a really important point and the reason why so many cases are settled. Now let's go back to this information and to the legal basis. This section of German Patent Act says the person obliged to provide the information shall give particulars of the names and addresses of the manufacturers, suppliers, and other previous holders of the products or of the users of the services, as well as the intended wholesalers and retailers, and the quantity of the products manufactured, delivered, received, or ordered. So a lot of information and in detail. And when you see, this is a part of the first stage, we file the suit. Number 1 motion will be the defendant is ordered to cease and desist upon avoidance of a penalty of up to 250,000 euro to offer, sell mobile phones, and now we describe the infringing product. Motion number 2 refers to this paragraph. The defendant is ordered to render information about date of delivery, number of units, etc. You may ask, what does this date mean? It is the date of publication of grant plus 1 month. German case law says every party has the obligation to inform itself about the publication of patents. But it is impossible that you see the patent and you realize the grant and you stop infringement immediately. So you have 1 month to consider it, then you have to stop it, and after 1 month it is negligent patent infringement. So this is the reason why this date here is not the publication of grant. It is a publication of grant plus some kind of grace period of 1 month, and only after 1 month you have to start to give information and you have to start to pay compensation. So this was number 2. You see it to provide the information. And now we have motion number 3. It is declared that the defendant is obligated to reimburse the damage caused by the acts according to number 1, this defines the infringement, which were committed after said date. So this is some kind of declaratory judgment. It only states that the infringer is obliged to compensate. And that's the first stage. You will not see any amount of damages to be paid, simply because the patent owner does not know how to calculate it.